Welcome back to Can't We All Just Get Along, Horst Legal Counsel's series on litigation and mediation philosophy and the role of technology in shaping the modern legal industry. A little while ago, I posted a video related to AI hallucinations. And no question that this is a major issue, especially for the litigators out there. Even in the intervening time between when I recorded the video and when it was posted, there were 2 California decisions that came out related to the use of AI in the courtroom, one of which was a Court of Appeal decision in Nolan versus Land of the Free, in which the Court of Appeal sanctioned an attorney $10,000 and referred him to the state bar in connection with his use of ChatGPT and other LLMs in preparing his appellant's opening brief. The court found that 21 of the 23 citations there were AI generated, as was a lot of the content in his reply brief. I want to talk, though, about the other case that involved deepfakes. Deepfakes is a phrase that a lot of people are learning. It's out there in the zeitgeist, but essentially it's manufactured evidence, right, in the case of litigation. These are documents that are generated using AI that are not real at all, and litigants are starting to submit these things into the courtroom to try to prove up their cases. I've seen throughout my career instances in which parties attempt to fake Word documents, maybe even a PDF, changing the metadata within those documents. This really takes that behavior to another level. And this other case that was out of the Alameda County Superior Court involved fake videos and fake text message threads that were simply done in sort of a ham-handed way, such that Judge Kolakowski in the Alameda County Superior could tell that they were fake in a few instances. And she was able, through applying logic to the content that was created, to be able to get to a point where she could throw the evidence out and, in fact, award terminating sanctions. The problem, though, is there was an even longer list of evidence of which she was deeply skeptical, but couldn't get to a level of legal certainty that they were fabricated. And the court noted that she didn't have the time, the resources, or the know-how to determine with certainty whether this evidence was real. And I think this is going to present a real challenge for litigators out there. How do you prove that something that doesn't track with what your client is telling you or everything else that you have read about a case? How can you prove that that evidence is real or is not real? And I think it's going to be a problem more and more as we go on. This is not going to be an isolated incident, as we're seeing with the use of LLMs in legal practice. We're going to see more and more of this, and it's a real question about how to deal with it. Let me know your thoughts.